Okay, so welcome to this panel on big data and criminal justice, equity and fairness. I'm Chris LeBogan. I'm a law professor here at the law school, and I also direct the criminal justice program. And I'm going to be introducing the panel you're going to be listening to today. As is true with anything having to do with big data and criminal justice is a very timely topic. Accessing, storing, and using information off the internet and other sources is becoming a very standard practice in a number of big city police departments and even in some small police departments. Algorithms are now behind the decision-making process in connection with pretrial detention and sentencing. Artificial intelligence, machine learning is starting to find its way into police surveillance practices. Probation officers and parole officers are starting to use social media to keep track of their charges. So it's becoming a brave new world in criminal justice. And a lot of people are in favor of this development. They hail this development because they think it will bring more accurate and more efficient ways of catching the bad guys and keeping dangerous people locked up. And more generally, they see it as still another example of how technology can make the world a better place. But big data developments in criminal justice are also extremely controversial because big data in criminal justice is different than big data in other areas in at least three ways. First of all, and I think this is very important to emphasize, of course, criminal justice involves deprivation of liberty. So when big data is used in this area, we're talking about deprivation of liberty, conceivably very prolonged deprivation of liberty. It's one thing to be identified by an algorithm as someone who likes books about murder. It's quite enough the algorithm says you are at high risk for reoffending. The consequences there are quite significantly different. Another difference between the criminal justice arena and other arenas is that first and foremost, criminal justice is about assigning blame for conduct. Assigning blame for conduct. And many of the factors that go into big data analysis in terms of evaluating criminality don't have anything to do with blameworthy criminal conduct, but rather conduct that's most likely innocent. Say, for instance, buying a gun or hanging out with certain kinds of people. And some of the factors that big data looks at in terms of determining criminality have nothing to do with conduct at all, such as being single and male and living in an inner city neighborhood. And I think a third difference between criminal justice and other areas where big data has played a role was suggested by what I just said. And that is that big data and criminal justice cannot avoid questions of race and class. So many of the factors that big data identifies as relevant to criminality may be very closely related to both of those characteristics. So all this adds up to a real volatile mix of issues which I think our panel is very well equipped to address. With us today we have 5 eminent scholars to talk about big data and equity and fairness in the criminal justice system. All 5 know about both the science and the law connected with big data and criminal justice. Whether it's the use of algorithms by the police to figure out who to stop and arrest, whether it's the use of big data to figure out who should be subjected to pretrial detention, or whether it's the use of big data to decide how long a person's sentence should be or released from prison. So, speaking first on the far end will be Andrew Ferguson. He's a law professor at the University of District of Columbia Law School, and he recently authored, I have a prop here, The Rise of Big Data Policing, Surveillance Waste, and the Future of Law Enforcement. Not surprisingly, he's going to be talking about police use of big data. Next, we have Megan Stevenson, who's sitting in the middle. We're not in order, so this is going to be somewhat confusing. Megan Stevenson is a law professor at George Mason Law School. She also has a Ph.D. in economics. She'll talk about big data and the decision about whether or not to detain someone after arrest and prior to trial, a topic about which she's written extensively. Third, we'll have Jennifer Skeem, who is a professor at Berkeley, professor of psychology, and one of the preeminent experts in risk assessment. And she'll be talking about big data and sentencing. So after those 3 speakers, we will have 2 other speakers who will riff on what the first 3 speakers talked about. The first speaker will be Sonya Starr, who is a professor of law at the University of Michigan and author of an article entitled Evidence-Based Sentencing and the Scientific Rationalization of Discrimination, among other articles in that vein. And then finally we have, and you can tell who the computer scientist is in the room, right? Goel. He's a professor at Stanford University with a Ph.D. in applied mathematics. and he's the author of Combating Police Discrimination in the Age of Big Data. So each of the speakers will talk between 5 and 10 minutes, and then I'm going to ask them to interact with one another for a while to see if they have any reactions to what the others have said. Maybe I'll prod them with a few questions, and then we'll open it up to the audience. I'm thinking that the panel discussion will go for about an hour, and then we'll have between a half hour and an hour to deal with interactions with the audience. We'll see how it goes. Before I let Andrew speak, I want to thank both the Data Science Visions Trans-Institutional Program, which is sponsoring this panel, and head of that operation, Andreas Berlin, wherever he is, right here. And I also want to thank Clint Stewart, who has been instrumental in organizing this whole process. So thanks to both of you and the institutional program itself for sponsoring this. And let's get started with Andrew.
Thank you very much for inviting me to talk about the future of big data policing, a future that in many ways has already arrived, about how new technologies are changing where police patrol, who they target, how they investigate, and in many ways changing the relationship between the police and the communities that they are there to serve. I want to talk in my short time here about 3 different technologies. I'll focus on person-based targeting, place-based predictive policing, and then social network investigations. Technologies that focus on people, places, and groups. In many ways because most crimes involve some person, some place, and many of them involve gangs or group activities. All 3 technologies share some commonalities. One, they are driven by the technology. The rise of big data policing is not a story that is really about chiefs sitting around thinking about what technologies would be useful to them. This is really a story about tech companies, startups, vendors, driving policing in different ways, in many ways, unthought-out ways. It is also a story about data, about big data, about the ways we can now visualize crime patterns and connections in ways we couldn't before, about how new technologies are shifting the way we can see what's happening in our community. And third, these are cases and stories that are distorted. What we learned before, our laws and our realities are changing because of what we can now see. The technologies are not good or bad in themselves, but they are impacting real-world effects. They're changing who gets handcuffed, who gets arrested, and who spends time in jail, and it's something we need to focus on. So in my short time, I just want to run through some of these technologies. First, person-based targeting. The idea is that using big data, using algorithms, we can identify individuals the most at risk in society, and then use and redistribute police resources to try and target those people. So I want to take you, make this concrete, into one city and one technology. Chicago, Illinois, and the heat list, the strategic subjects list. Right now, in Chicago, there's an algorithmically derived list of individuals who the Chicago Police Department think are the most at risk for violence, either as the perpetrator of violence, the shooter, or the person to be shot. If you make this list, you get a threat score from 1 to 500 plus. And if you're high enough on this list, you may find a Chicago detective at your front door, knocking, maybe with a social worker community member, to tell you, A, you've made this list, B, here's a letter, it's called a custom notification letter, with all of the information about why the police think you're on this list. And then essentially, kind of a scared straight warning. You got 2 choices in life. If you continue on this path, you're going to end up either arrested or shot. Or maybe you want to turn your life around. On one hand, it's kind of a social control mechanism. On the other hand, it's sort of a public health approach to violence. How do you get on this list? Well, here are the inputs. Whether you have been arrested for a violent crime, a narcotics crime, or a weapons offense, whether you've been the victim of an assault or a shooting, your age at the last arrest, the younger the age, higher the risk score, and then kind of the trend line. Is this aging? Are you aging out? Are you aging up? Are things increasing in it? How do you get off the list? You don't. In fact, maybe your number comes down, but there's no actual way at this moment to get off the list. Why do we have this theory? This isn't simply big data targeting. There is a theory behind this of focused deterrence. That risk is not evenly distributed across society. There are more people who are at more risk because of their lifestyle, behaviors, and friends and associates. And the idea is to maybe quantify that in a way, sort of a public health approach to violence. That's the theory. The reality is that a lot of the funding going behind the social services weren't fully funded. So some people will complain it's really just a virtual most wanted list, being able to sort of go to the usual suspects a lot quicker because you've already literally given them threat scores in their lives. And the problems are transparency. There's an issue of the algorithm still secret. You have race issues, so race gets included in this data, right? If you're using arrests as your inputs, you know arrests are kind of proxies for where police patrol, and you know you have a city like Chicago where the Civil Rights Department of Justice did a whole study about racial bias in Chicago and found that yes, there is racial problems in Chicago. You're going to have an issue of that the inputs are going to be encoded with this racial bias, which is going to impact your output. The reality is that I think over 50% of all African American men from 20 to 29 are on the heat. That's people, places. There's also technology about patrols. Where do police patrol? The idea behind place-based predictive policing is that you forecast enough crime data, you'll be able to predict ahead of time where the next crime will be, and the goal is to send a police officer or a police car to that area to deter it. You predict and you deter based on the past crime data. How do you get this data? Well, you look at past crime patterns. You look at where crimes have been reported, when it's happening. Some of the simple algorithms really just have past crime time locations. Some of the more complicated algorithms or models really add in other things like day of the week, Fridays or paydays, you might see an uptick in robbery. Weather patterns, when it rains, bad guys don't like getting wet, and so like crime goes down. And so the models can change, and they're actually sophisticated enough that if you actually go back and look at those red squares, you might be given that roll call. Or the even more sophisticated ones, you might be driving in your police car with your police computer in front of you, and literally the areas will change color as you drive through a high burglary area or a predicted aggravated assault area. The theory, again, is that some crime is sort of viral, it's contagious. If a house gets burglarized in one neighborhood, it's actually more likely that other houses in that neighborhood get burglarized. Why? Because some people who burglarize the house figure out there's some vulnerability here. So they're going to go back, and the word will get out, and there'll be more burglaries in the neighborhood. It actually shows with car thefts and burglaries that some of these crimes really do have those impacts. The reality is it's literally changing police patrol. It's literally changing where police go, what neighborhoods they target, and why they're there. And it also distorts how they see their work. They're now knowing or thinking that they are in a burglary area or a high aggravated assault area, and that's going to impact how they see the community, how they see the people in those areas, and obviously might impact reasonable suspicion and other legal issues there. Problems, again, transparency. Some of the technologies are proprietary. You don't know where they are. You don't know how they work. Race is obviously a potential concern depending on the inputs you put in. And then again, there are these constitutional distortions about how it's going to change suspicion on the streets. And the officer is literally told by computer, be on the lookout for burglars in this block at this time, at this moment. Final technology is social network analysis. The idea of being able to bring connections together, unseen connections to use for investigation and or monitoring populations you believe are more at risk. If you are in Los Angeles, you might have partnered with Palantir, because they have. Palantir, the same company that brought you how to target terrorists across the globe, is now targeting group crimes across Los Angeles. The idea is to be able to find these connections and then do link analysis to determine who's connected to whom. Maybe it's a phone number, a car, a tattoo, a girlfriend, a grandma, a location. All these links are then brought in to focus on the folks that the LA calls their quote-unquote chronic offenders. What they do when they have these chronic offenders, they send police out to do contact cards. And in fact, they have these little cards up there get filled out every time there's a chronic offender, and those cards then get brought back and inputted into Palantir's system as they grow this wonderful investigative network. It's actually changing, distorting kind of what police do and how they're supposed to do their job, because they become kind of data collectors, but it also does create a pretty powerful investigative tool. So there are positives in the sense of you're able to monitor and map and see patterns that you wouldn't have seen before across jurisdictions, across groups. And of course, there are negatives. It is a form of social control. You're now monitoring people who wouldn't otherwise be in it. And in fact, one of the concerns that people have raised is that the power of the link analysis, not only of the targets, but all the associates of the targets. So you're getting all these people who actually don't have any criminal suspicion, but are connected and are thus being brought into these larger big data technologies and databases. In my book, thanks, Chris, I say all big data policing has a black data problem. Black data being problems of transparency, race, and constitutional distortion. I won't go into it now. But the idea being that there's a black box problem, right? These are algorithms that are hard to understand. Most people in this room accept it, don't understand it. A lot of the vendors are dealing with proprietary software you couldn't even understand. You couldn't get access to it if you wanted to it. Other problems are race, and there are obviously problems of constitutional distortion. I don't want to step over my 5 to 10 minutes, so I'm going to stop saying that you have more.
Sure, yeah, thanks. Hi everybody, my name is Megan Stevenson. I've been asked to speak to you today about the use of risk assessment algorithms in the pretrial context. And I wanted to start off with a little bit of background information. So for many decades, the predominant method of determining whether you were going to sit in jail between the time period of when you're arrested and when your case is adjudicated has been monetary bail. In a bail hearing, which, by the way, typically only lasts about a minute or two, the judge will look at your offense, look at your criminal history, and set your bail amount. Maybe lower for those with less serious offenses, higher for those facing more serious charges. And if you can afford to pay this bail amount, you can go home. If you can't afford to pay, you must sit in jail until your case is completed. In recent years, this system of determining pretrial custody has been under attack. Critics argue that incarcerating people just because they're poor amounts to not just an unethical behavior, but also an unconstitutional practice. In essence, it amounts to discrimination on the basis of wealth and leads to high rates of pretrial detention despite the presumption of innocence. Furthermore, the money bail system, people argue, is inefficient. You're spending taxpayer money to incarcerate people, poor people, even if they don't necessarily face a big crime risk, while the Bob Dursts of the world go free. These questions are important because there's a lot of people detained pretrial. Pretrial detention accounts for approximately 90% of the growth in the jail population over the last 20 years. And there are actually more people in jail awaiting trial than there are serving time due to a drug sentence. With numbers as big as these, it's important to get the pretrial custody decision right. The use of algorithmic risk assessments in the pretrial context has emerged as one possible answer to the problems of monetary bail. The idea behind this is that instead of making the pretrial custody decision on the basis of wealth, you make it on the basis of risk. In specific, the risk of reoffending or the risk of failing to appear in court. Proponents of this line of thinking argue that risk is best evaluated with the use of big data and statistics. Instead of relying on the hunches and ad hoc intuition of judges, we can crunch the numbers. We can identify people who are at relatively high or relatively low risk of reoffending by analyzing the correlations between these outcomes and inputs such as age, the criminal record, the current charges, gender, employment status, education, and so forth. Those who are identified by the algorithm as being at high risk of reoffending or failing to appear in court can remain detained pre-trial or actively monitored, and everyone else can go home. So this idea has become enormously popular. A prominent group of researchers conducted a policy simulation that said if New York City adopted their risk assessment instrument, they could lower incarceration rates by 42% without affecting public safety. A billionaire couple from Houston, one of whom was a former gas trader at Enron, has sunk tens of millions of dollars into developing and implementing a pretrial risk assessment tool. Within the space of a few years, dozens of jurisdictions, including 3 entire states and several of the largest cities in the country, have adopted this tool. A bipartisan bill, yes, they do still exist, co-sponsored by conservative Rand Paul and Democrat Kamala Harris, would provide funding to states to replace their money bail system with a pretrial system based on algorithmic risk assessment. Since last year, almost every state in the nation had an active bail reform movement going on, and the majority of these reform efforts involved an algorithmic risk assessment tool. Simultaneously, however, there has been a growing counter-movement of people that are in favor of bail reform, but opposed to the use of algorithmic risk assessments. This movement is based on a number of concerns. For many, it just feels weird. Like in the film Minority Report, people are being punished for crimes they have not yet committed on the basis of a computer-generated algorithm. Some of the algorithms that are used in the pretrial context are proprietary, which means that the algorithm is secret and owned and maintained by a for-profit company. This raises serious due process concerns. If your freedom is being determined by a secret algorithm, how can you challenge it? Furthermore, what if these algorithms are racist? Even race isn't included as a specific direct factor in the algorithm. There are many factors that are included that are correlated with race. Education status, employment status. Even the criminal history inputs are the function, such as the number of prior arrests, are the function of racially biased practices. If you grew up in a neighborhood that is heavily policed, you're simply more likely to have a number of prior arrests than if you had committed the same acts but lived in a wealthier neighborhood. An algorithm that is trained on racially biased data can't help but to reflect, and worse, may even perpetuate racial bias in our society. Finally, there has actually been no proof that the dramatic efficiency gains that were promised as a result of risk assessment, simultaneously lowering both incarceration rates and crime, have been achieved in real life. The real-world impacts of adopting risk assessment have been mixed. In some places, incarceration rates have gone up. In other places, incarceration rates have gone down. And nowhere have you seen a dramatic decline in incarceration without at least some offsetting increase in pretrial crime or failures to appear. These types of critiques have rubbed some of the luster off of pretrial risk assessment. Some advocates argue that risk assessment has been too closely linked to the bail reform movement, that you can get rid of the problems of money bail and create a smarter and more fair pretrial system without the use of these potentially racist tools. But the question still remains, even if risk assessment is imperfect, is it better than the status quo? The status quo method of evaluating risk, which occurs inside the judge's head, is more black box than even the most proprietary risk assessment instrument. And furthermore, in many instances, it may be racist as well. Perhaps the better question is more specific. Can a bail system be designed that takes advantage of the strengths of risk assessment instruments while minimizing its weaknesses? Perhaps this could involve designing an algorithm that intentionally minimizes the racial bias issues that I mentioned earlier. This algorithm could then be used as a way of granting automatic release to a large majority of people that are arrested. Remember, these people are ones who are presumed innocent and who the Supreme Court said should be detained only as a limited exception. And then, before detaining someone pretrial, perhaps you could require something more than this 1 minute long bail hearing. A full hearing in which there is defense counsel present and evidence examined, and so forth. So these issues remain a subject of active debate, and I look forward to discussing them with you more today.
Should I use that? All right. Sorry, just let me try one thing. Okay, so I'm going to talk about the use of risk assessment in sanctioning. So briefly, for the uninitiated, risk assessment it's broader than algorithms, and it has an older history than algorithms. It's basically any kind of data-driven evaluation that's designed to estimate the likelihood that an individual will reoffend. And typically, in the olden days, that meant that you looked at risk factors that robustly predicted reoffending, and you summarized those in an instrument, so you add them up, in essence. So this is related to, but also different than, the more common and recent development of using algorithms to predict recidivism. So risk assessment has really seen a resurgence in criminal sanctioning, including sentencing, and it has been the subject of debate, and there have been some developments. And I'm just going to try to provide a brief snapshot of both of those. First, with respect to the promise, there has been, risk assessment has been part of probation and parole for a long time. Judges have always relied on some kind of intuitive or informal assessment of risk. But with criminal justice reforms that have come onto the scene in recent history, we're seeing risk assessment being applied in many ways, in many jurisdictions, in ways that it hasn't before. And that includes sentencing. So in theory, at least, given that we have a problem that is well recognized now with mass incarceration, one would think, as Megan just pointed out, that one way to safely reduce mass incarceration is to release the people who are least likely to return. And there is at least one example of success here. By implementing risk assessment, Virginia has diverted about 25% of its prison-bound, low-risk offenders from incarceration without increasing the crime rate. So this is a single example, and it's often trotted out. We need much more research. But if we summarize this, proponents of risk assessment point out that compared to the status quo, again, so compared to unaided judgment of probation officers, parole officers, judges, etc., risk assessment can increase the consistency, transparency, if it's done correctly, I will argue, and accuracy of decision making. At the same time, there's also clearly peril. Former Attorney General Eric Holder expressed concern publicly in a speech where he said that relying excessively or broadly, too excessively or broadly, on risk assessment may exacerbate unwarranted and unjust disparities that are already far too common in the justice system. We got there, by the way, without risk assessment and algorithms, so I just want to point that out. They are already far too common. Sentences should be based on the facts, the law, the actual crimes committed, and the defendant's history of criminal conduct. In other words, a very backward-looking focus, a retributive focus. They should not be based on unchangeable factors that a person cannot control or the possibility of a future crime that hasn't taken place, which is about risk assessment, which is forward-looking. Similarly, Professor Starr, who is here, has argued that sentences that consider risk assessment are probably discriminatory because in addition to criminal history, which is a consideration that she thinks is legitimate, these risk assessments also include some of the factors that we've mentioned here, like employment, education history, neighborhoods. There are many other factors that don't have anything to do with blameworthiness for a past crime and may be associated with low socioeconomic status and race. This has come into high relief with a publication by ProPublica titled Machine Bias. But to just distill the peril here, risk assessment can add a veneer of scientific objectivity to decisions, which may give them too much credibility, and also may have unintended disparate impact. Before I talk about developments that are really directly relevant to that debate, I just want to distill some basic premises very quickly. So the first is that if risk assessment plays any role in front-end sentencing, which is an open question, people are pretty consistent in saying that it must play only a limited and secondary role in sentencing. So offenders should never get a more serious sentence than they morally deserve based on those backward-looking concerns on the basis of a risk assessment. So if the morally appropriate sentence is in the range of 5 to 9 years, for example, risk assessment could be used to consider a sentence at the upper range, 8 to 9 years, for the highest risk offender, and the lower range, 5 years, for the lowest risk offenders. Second, beyond being well validated, which goes without question for any use of risk assessment, when you're talking about using risk assessments in sanctioning, there are other requirements that have become very clear in the literature over time. The first is that they really need to be transparent. We can't have some of the black boxes that we've been talking about. We need to know what is under the hood to be able to see what risk factors are in the equation and how they're being weighted. So they need to be subject to scrutiny and challenge. Second, we need to omit legally questionable predictors like race, which virtually all tools do. Third, we really need to be able to show that these instruments predict a criterion that's subject to relatively little selection bias. So something like violent rearrest involves less discretion than something like a drug crime. So we need to pay attention to predicting new crimes, new victims, something that we actually want to prevent. And the third is less a prescriptive than a fact, at least in the risk assessment literature that's developed over the past 50 years. We have seen across many domains that if you have a validated risk assessment that is designed to structure human judgment or replace it, that has been shown to predict violence or other criminal behavior more strongly than seat-of-the-pants, unaided professional judgment. We can talk more about, there was a high profile recent study that suggested otherwise, but there are all kinds of issues with it. So back to the debate. Those are premises, back to the debate. You could summarize this as the following question. Does the use of risk assessment to inform sentencing exacerbate sentencing disparities as Holder and others expect, or does it mitigate those disparities or have no effect on them? This is an open empirical question. So that question hasn't been answered, but recently there have been a lot of developments with respect to risk assessment and sanctioning. Almost all of these developments focus pretty narrowly on looking at the racial fairness of the risk assessment instrument itself. So not as applied, but the risk assessment instrument itself. There have been a lot of racial fairness criteria that have been offered and discussed. It can be confusing to read this literature because sometimes different terms are used for the same criterion. But they are overlapping, and they can generally be grouped into those that emphasize crime prevention and those that emphasize social justice. I'll show you examples of those in just a moment. But the preview, which really Sharad has shown better than anyone else, is that we've learned that it's really difficult to be fair in both crime prevention and social justice ways at the same time. And that's not a function of risk assessment. That's a function of life. So whether you're a human or an algorithm, you face this difficulty of trying to be fair in both ways at the same time. So to give you an example of this, my colleague Chris Lowenkamp and I have done some analyses of the post-conviction risk assessment on large cohorts of federal offenders. And we've found, I'll show you 3 things that we found, in essence, that illustrate this point. The first is that we found no evidence of predictive bias by race. So predictive bias, the way that we defined it here, is defined in terms of the definition of test bias that the standards for educational and psychological testing establish. So according to these standards, if a test is unbiased, a given score means the same thing on that test regardless of what group you belong to. And that is what we found here. So you'll see that given a PICRA score of 10, for example, the probability of rearrest is about 42%, whether you're talking about a black offender or a white offender. These are crime prevention focused fairness criteria, right? So predictive fairness, calibration, positive predictive value, those live in this domain. At the same time, we found that on average, black offenders obtained modestly higher PCRA scores than white offenders. So the difference was about 1.5 points on a 16-point possible scale. So it's a small difference, but it's meaningful, arguably. It's important to point out that mean score differences or score differences in general are not necessarily indicative of test bias because they can reflect real differences. In the United States, for example, race is associated with socioeconomic inequalities that can be associated with criminal behavior. Even if these score differences aren't indicative of test bias, they're still relevant to disparate impact. So use of the PCRA, even if it perfectly predicts recidivism for both groups, could still result in inequitable social consequences. The important additional finding here, though, is that virtually all of the difference in scores, 70% here, is attributable to criminal history. So again, criminal history is usually treated as the least controversial risk factor. It's already deeply embedded in sentencing guidelines. Third and last, and in a related sense, we found that given those who did not reoffend, a higher proportion were labeled as high risk by the PCRA for the black group, 8%, compared to the white group, 5%. So again, this is another social justice criterion that focuses on false positives and the difference in false positives. So as you're going to hear more about later, it is impossible to be perfectly fair both ways at the same time. This is one of the things we've learned. I won't go into this into detail because again, you'll hear the reasons later. But I want to underscore that this problem applies equally to human decision makers. It's not solved by abandoning risk assessment. If you have really good prediction and a higher recidivism rate among black offenders, you're going to have more false positives. So this kind of puts the question back in the policymakers and legal decision makers domain. This is not a problem that can be solved by an algorithm or a computer or by ignoring the algorithm or computer. We can see the trade-offs in risk assessments. We can identify them. We can prioritize what trade-offs we really want. And we can build them into risk assessments. I don't have time to talk about this, but we've looked at the PCRA with a criminal history discount and found that it decreases false positives for blacks. At the same time, there are trade-offs in terms of overall predictive value. Okay, so the main point that I want to make, though, so those are the developments. In my view, they sort of underscore rather than answer this fundamental question, the question that we all want the answer to, which is, does the use of risk assessment to inform sentencing exacerbate, mitigate, or have no effect on existing racial disparities in incarceration? We can't answer that question by focusing on instruments or algorithms by themselves. This is inherently a question that brings humans into the mix at some point, and it's also inherently a comparative question. So the question is about risk assessment and sentencing compared to what? So compared to what, in this case, is existing sentencing practices. If you take a given instrument with known properties, whether it increases, decreases, or has no effect on sentencing disparities will depend on what practices are being replaced. So there are lots of variation in current practices, but there are two common denominators. One is judges' informal consideration of risk, which we know has been part of sentencing for a long time. That informal consideration of risk is subject to biases that we can't measure, can't see, and also tends to be inaccurate relative to more structured approaches. The other common denominator in many jurisdictions is sentencing guidelines, which heavily emphasize criminal history and have been shown for that reason to contribute pretty markedly to racial disparities in incarceration. So my current view is that putting the brakes on risk assessment would be pretty myopic, that this is a tool still for safely unwinding mass incarceration. There are lots of different applications, some more defensible than others. And it's also a way for us to see, to shed light on existing racial disparities and what we can do about them. And I just want to recognize my collaborators, Chris Lowenkamp, John Monahan, and Chris Lebogan. Thanks.
I'm Sonya Starr. It is an honor to be here. Thank you to Chris and to Andreas and Quenna for organizing. I am always the designated graduate naysayer on panels like this, so I want to start by saying that in general, I am in favor of using data to improve the practice of criminal justice. I am an empirical legal scholar focused on criminal justice. It's sort of what I do for a living. But I am quite disturbed by the way that actuarial risk assessments are being used in criminal justice. I will start by clarifying exactly what I'm talking about. Like Jennifer, I'm going to focus mostly on the use of risk assessment to determine either the sentence at the front end or parole decisions, which is really the oldest and most ubiquitous use of these instruments. I do think that similar issues are likely raised at the bail stage and perhaps at the policing stage. I'm also not particularly focused on big data, right? As Jennifer points out, traditionally these risk assessment instruments have not really been big data instruments. They have been checklists, risk scores that tally up a bunch of risk factors, and they're loosely based on the regression coefficients from some prior study, right? Traditional statistical mechanisms, but very loosely, right? And that's overwhelmingly what's still being used now, right? This move toward machine learning type algorithms is really new. In substance, though, I don't think it really that shift actually really bears on anything that I'm going to say, because I'm not really going to focus on the predictive accuracy. I'm concerned about certain fairness issues, partly procedural fairness issues, right? The fact that many of the most common risk instruments are proprietary corporate products that a defendant literally can't get access to, like they're told the weights of the variables that go into producing their risk score, which makes it very hard to challenge. That is an outrage from a procedural justice perspective. But I'm going to focus mostly today on the substantive fairness issues, namely the variables that go into the instruments, whatever algorithm you then use to get the output of the instruments. So, there are different jurisdictions that have different variables involved. I am going to focus again on the kind of big mainstream instruments, like the big corporate products like LSIR and Compass. So just to be clear on what the variables are, I'll sort them into 5 different categories. First, there's criminal history, which those are the most universal. Second, is socioeconomic variables, which can include past and present unemployment status, education, financial stability, ability to pay bills, past and present housing instability, where you live, whether you or a family member has been a victim of crime. Also, variables related to one's family background and other associations. So, do you have family members in prison now or in the past? Do you have friends with criminal records? Do you have a strong relationship to your parents? Also, demographic variables, in particular gender, age, and marital status are the most common. Then there's a lot of the instruments have these psychological or social attitude variables, which are generally based on an interview with some corrections official who assesses things like whether you have an oppositional attitude toward the justice system or authority or social norms, etc. In general, race is not among the variables. That wasn't always true. It used to be that parole instruments in use in most states included race explicitly. And those really, actually surprisingly recently, like until the 70s, that was true in some jurisdictions. In any case, the facially race-neutral instruments, virtually every single variable that I just mentioned, other than maybe gender and age, are strongly racially correlated, right? So it's obvious that if you use those types of characteristics, you're going to get higher risk scores for people of color, especially for young black men who are already the people who are being the most heavily incarcerated. In my view, many of the variables that go into the scores are simply inappropriate factors to base a sentence on. It's a really simple argument, right? Like, I don't think the test is predictive bias, like whether the instruments are equally accurate. There's just some things that even if they do help an instrument to become more predictively accurate, that just shouldn't be bases for treating people differently in the criminal justice system. Almost everything I just mentioned it can be characterized as a marker of poverty or social disadvantage. It's not just that they might be associated with poverty; they are poverty, right? Like, they literally include socioeconomic variables in the formula, like, I'm not saying that those things aren't correlated with recidivism risk, although we should note that in all the recidivism studies, the thing that's being measured is not criminal recidivism, it's arrest, right? Or it's some measure of criminal recidivism that turns on the system knowing that you recidivate, right? And so it is not surprising that people who live in poor neighborhoods and have past exposure in their families to the criminal justice system, et cetera, are also more likely to be arrested in the future. That would be true even if they didn't commit more crime. But let's assume that they do commit more crime, right? I still think those factors that I listed, most of them, are not appropriate factors to rely on. And I think that to say that judges are also free to take into account moral desert, et cetera, like other sentencing factors, I mean, that's good. But when we give a judge a risk score and we say, take this into account, and it embeds within it all those factors that I mentioned, we are as good as saying that the state wants the state thinks that poor people should be sentenced for longer, right? Because in general, not in every case, but why else would we give a risk assessment instrument that uses factors like that and adds points to people's scores and then tell judges, take this score into account, right? If we didn't want them to actually change some people's sentences such that some people get sentenced more because of all of those risk factors, then we wouldn't give them to them in the first place. So yes, of course, it's not the only factor in sentencing, but it's a factor, and it's one that shouldn't properly carry weight. I have set forth a constitutional argument against the use of socioeconomic variables as well as gender in risk assessments in the article that Chris mentioned. I don't think that argument is especially boundary pushing. The lawyers and law students in the room will know that the gender argument is completely straightforward, right? It is very difficult to justify explicit gender classifications in the law. And in fact, the Supreme Court has again and again said we can't base differential government treatment on generalizations about how people of different genders behave, even if those generalizations are statistically accurate. It said that in case after case after case. And that really is... So it's basically rejected the idea that the measure is whether something is actuarially fair, right? Whether it's equally predictive. The idea is that certain considerations are just not supposed to be taken into account. Now, I can see the argument in favor of an actuarial fairness approach to thinking about fairness in prediction. But it is super clear where the Supreme Court stands on it, and it's not on that side. Now a lot of us just don't really care very much about discrimination against men, like cry me a river. But it is true that like the men in the criminal justice system are not a particularly privileged group, right? And gender discrimination, or rather, in this case, discrimination and disparity, intersects with other vectors of disparity to produce extremely elevated incarceration rates for certain groups, especially black men. That is something that I think that criminal justice reformers should be concerned about, and gender is one dimension of that problem. The problem with the socioeconomic variables is equally clear from a legal perspective, and I think even more troubling from a policy perspective. There is a long line of cases, so lawyers and law students in the room might not be as alert to this because we are sort of taught first year of law school, oh, like nobody pays attention to class-based discrimination, right? This is not like race or sex. It's not something the courts take seriously. That's not true in the criminal justice system. There is a long line of cases about treating poor defendants the same that you treat rich defendants. In a case called Griffin, the Supreme Court referred to the provision of equal justice for poor and rich defendants as the central aim of our entire judicial system. And in a case called Bearden v. Georgia, unanimously decided in 1983 and still good law, the Supreme Court considered whether it was okay to make somebody's punishment turn on the statistical generalization that people who are poor or don't have jobs are higher recidivism risks. In Bearden, his probation had been revoked when he lost his job, and that statistical argument, backed up by a raft of empirical studies, was one of the arguments the state put in to try to defend it. The Supreme Court threw that out roundly and said that you can't just punish people on the basis of lumping him in with other people who share his socioeconomic status and saying statistically people like that are of higher risk, because that's nothing more than punishing a person for his poverty. That is exactly what today's risk assessment instruments do in a more modern, like fancier form. I'm similarly bothered by the family status variables. That's a little more unsettled legally, but I don't think you should be sentenced to longer because your parents went to prison. I feel like that should be obvious. For all those reasons, I mean, I'm sort of surprised that risk assessment has been so embraced by a large fraction of the progressive criminal justice reform movement. And I do think there's reasons for it, largely because, as Jennifer said and Megan said, like the starting point is pretty bad, right? Like we have a mass incarceration problem. The money bail system is a catastrophe. Individual decision makers also do bake in biases, and so there's this idea that moving toward actuarial risk assessment will rationalize the process, make it more scientific, less bias-driven, and hopefully will be a way of unwinding mass incarceration. A couple of things on that. First, I don't think we can assume that judges are only going to rely on the low-risk assessments and not the high-risk assessments, right? They're going to detain some people for longer or more often because they're high risk. And some of the risk assessment instruments that are being used actually bake in a preference in that direction by the way that they balance type 1 versus type 2 errors. Like the policymakers have decided it's worse to let someone go who goes on and commits a crime than it is to detain someone who wouldn't have gone on to commit a crime, and so they err in the direction of incarceration. I feel like the desire to make things more rational and scientific, I see the appeal of it, and people defend the practice using buzzwords like evidence-based sentencing. Who could be opposed to evidence, right? But look, there's a better and more common word for what is happening here. It is called profiling, right? This is a form of profiling, and I think if we think about if we didn't couch all this in terms of a statistical risk assessment instrument, like what this would look like do this thought experiment. A judge comes into the courtroom and says, well, defendant, like I was going to sentence you to probation, but then I realized that you've had housing instability in the past, and your parents went to prison, and you're not married, and you only make minimum wage, and everyone knows that people like you are dangerous, so I'm going to send you to prison instead. There would be gasps in the courtroom, right? It would be an outrage. And if a legislator stood on the floor of the state legislature and said we should systematically put that kind of judgment into our sentencing scheme, that would also get produce gasps, I think. But when you use these the veneer of scientific objectivity, as Jennifer put it, to cover that. I think a lot of people don't quite see that those judgments are baked in to the instruments, right? They're just like, oh, it's a risk score. Why wouldn't I want to rely on that? It's science. And I think people maybe, like people in this room are thinking deeply about these things, but I think a lot of judges, like, they don't get the policy stakes or the equality stakes that are being baked in. So I don't think we have a forced choice between giving up on addressing mass incarceration in other ways, between giving up on the problems in the money bail system in other ways, and choosing a system that locks in, that sort of makes explicit some of these discriminatory bases, right? Like, we could have things like Virginia's diversion program and not make the door into that program controlled by an actuarial risk assessment instrument, at least one that bakes in problematic variables, right? The choices that need to be made are substantive choices about bringing the incarceration rate down and enforcing the Eighth Amendment, like excessive bails provision, and like having, there's all kinds of policy judgments about the role of the criminal justice system that can be made without locking in an alternative form of discrimination. So I don't know which is worse or which is better, but I just think those can't be our only options.
Hi, I'm Sharad Goel. So lots of interesting comments from Sonya that I'm looking forward to getting into when we go to the panel format. But for now, I want to back up and talk about this article that Jen alluded to earlier, this ProPublica article about machine bias, and I think the headline pretty much says it all. So this was in reference to these pretrial algorithms, Compass in particular. Machine bias are software used across the country to predict future criminals, and it's biased against blacks. So it's a pretty explosive claim, and obviously if this is true, then we have a serious problem in these algorithms. It's not hypothetical, these are actually being used across the country. So let's just jump into what is the basis for this claim. So it's this. So let me try to say it in words. So among all defendants who do not go on to reoffend, we follow them for 2 years, we look at all defendants who do not go on to reoffend, then about 31% of black defendants are deemed high risk by the algorithm, versus 15% who are deemed white defendants who are deemed high risk by the algorithm. So among everybody who does not go on to reoffend, black defendants are about twice as likely to be deemed high risk than white defendants. And if you're deemed high risk, then let's assume that judges actually take these recommendations into account. Then you are burdened with all the penalties of high bail and detention. So how many people think this is bad? Don't be bashful. Who thinks these are bad? So if you really think that these are, if you believe it, then I think we pretty much have to end pretrial algorithms. The use of pretrial algorithms, if this is not just one particular jurisdiction, this is almost certainly happening across the country. Now, I'm going to try to persuade you in 5 minutes that you actually shouldn't be so concerned with this number. So, as a token computer scientist, I'm going to force you to do a little bit of algebra. I'll try to keep it minimal. I know it's still early in the day. So let's say we have these two groups, blue group and orange group, and we just have them lined up according to their risk. Low risk people on the left, high risk people on the right. In both of these groups, we have this line. This is going to be our binary distinction between high risk and low risk. That's our algorithmic assessment. And we have these two different groups. They're not lined up perfectly identically because, as in any two groups, you're going to have differences in the distribution of risk. Okay? So now, let's try to understand what does false positive rate mean in our blue group. So again, just to remind you, what is the definition of the false positive rate? It's the ratio of two things. Among people who do not reoffend, how many were deemed high risk? Okay, so that means that we have to look at all these blue people. We have the likelihood that they reoffend, so we just have to add these things up. And we're going to say some of them will not go on to reoffend. That'll be our denominator. Our numerator is people to the right of that dashed line who do not go on to reoffend. So what is that in this case? I'll do the math for you. It's about 2/8. So we have 25% false positive rate. Okay, among people who do not go under reoffend, how many are deemed high risk? Let's do the same thing for the orange group. Nothing fancy going on. We're going to do the exact same exercise. There are a lot more people to that right of that dashed line. Here we have about 2.5 people on the top, and we have 6 people on the bottom, 42% false positive rate. Okay, so this is pretty much the ProPublica situation, that we have our blue group and our orange group. In our orange group, the false positive rate is considerably higher than in the blue group. And so this suggests that the algorithmic decision rule is biased against the orange group. Good? So nothing going on so far. Now, here's the trouble. Let's take our orange group, and let's say we don't like this. We're in some jurisdiction, and someone has just called us out and said, hey, your tool is biased against the orange group, but you don't actually want to change your algorithm. What are you going to do? All you have to do to fix this problem it's super simple. All you have to do is go out and arrest some college protesters and then immediately release them. Very simple. Cost effective, you just arrest them, and then you immediately release them. It's totally reasonable to release them because they're low risk. So your algorithm hasn't changed. It still says, release everyone who's low risk. You arrested a bunch of college protesters, you immediately release them, and now what's going to happen if you do this? Well, we'll look at false positive rates again. The numerator, the people who are both high risk and who don't go on to reoffend, it doesn't change because no one in this extra group was deemed high risk. So the numerator is the same. The denominator, all of a sudden, I have a bunch of people in my population who are relatively low risk, and so I can increase my denominator. So this is going to bring my false positive rate down, and in fact, they're now equal. And all I had to do was arrest college protesters. So again, from here, so this is biased. This is a racist algorithm using this language of false positive rates. And to make it fair, I just need to arrest some college protesters. So easy solution. So of course, this isn't the point isn't that you can game these statistics. The point is that you actually don't know ahead of time what's going on. And so is it the case that this is really the situation that you're reasonably arresting a different distribution of people in the population, and that's what's causing these differences in false positive rates, or something else going on? You can't tell if I just give you that raw number alone. So if you hear one group has a higher false positive rate than another group, you can't actually figure out if it's biased against one group or another. Now, that's not to say that the algorithms aren't biased. It's just to say that this argument for raising concern about bias isn't particularly well-grounded. So what can we do and what should we do moving forward? Well, I think this has already come up in various forums already. Algorithms are extremely good at synthesizing information. It's a very narrow task. I mean, statistical methods in general are much better than humans at synthesizing information, but certainly that's disconnected from the policy question. And I think this is where all the tension comes in, that we need to set equitable policy, and that often has very little to do with the algorithm itself. So the algorithm is going to give us some score, but what do we do with that score? It's going to give us some estimate of some particular outcome. So what is it, in these types of cases, what is it telling us? It's telling us the chance of somebody being rearrested if they were released, and now we should decide what do we do with that piece of information. It's not necessarily telling us the likelihood that they commit a crime. It's telling us rearrest. It's not telling us what's going to happen if we instead give them some more robust social services. It's not telling us what happens if we end the money bail itself. It's telling us this very narrow piece of information. What is the likelihood that this person will be rearrested if released? That's it. And the policy question is a much harder question than the statistical question, which I think tend to get conflated, but in my mind it's important to keep these things distinct. Thank you.
So I want to thank all the panelists for terrific discussions. Obviously there's a lot that's been raised by these 5 presentations having to do with risk assessment, having to do with race, having to do with the kinds of factors that go into these algorithms and uses of big data. So what I'd like to do is let the panel react to one another first. I think there've been I think if you were paying attention, you can see there are maybe some incipient disagreements between some of the panelists, and I think it might be nice to expose those to a little bit greater extent than has been done already. And so if any of the panelists have anything to say about what the others said, great. Otherwise, I'll try to trigger some disagreement, but I want to see, first of all, what we've got on the panel. Nobody want me to? Okay, so I think Sonya's comments were particularly provocative and interesting, and I'm curious what the panel thinks about what the implications of her comments are. Should we get rid of risk assessment entirely in the criminal justice system because it's rife with bias and the kinds of problems she discussed? Or should we just get rid of actuarial risk assessment but still rely on judges to make risk kinds of assessments? I think that's a good question to throw out. It really gets us to the question of whether data ought to be used or not, or whether instead we ought to rely on good old common sense in terms of dealing with issues that come up routinely in the criminal justice system, which is how risky is someone. Should we care about that issue at all? And if so, how should we try to solve that and answer that question?
I just wanted to say, I actually, correct me if I'm wrong, Sonya, but I don't hear you saying let's get rid of risk assessment. I hear you saying let's get rid of these problematic variables. There are certain risk assessments that are based entirely on criminal history, and I think those still have problems with them, but it's a different question. I actually do agree that you should get rid of socioeconomic proxies in risk assessments, and I'm not certain about gender.
So there has been a move actually in the last couple of years in some areas to taking the socioeconomic variables out of some of the risk assessment instruments, especially some of the common bail ones, and making them largely criminal history based, sometimes like age, sometimes gender thrown in as well. I think that reliance on criminal history, there's no doubt that it's constitutionally permissible, right? The arguments that I just made do not apply on the legal front to the use of criminal history, which is utterly ubiquitous in the criminal justice system. I do think that because it is utterly ubiquitous in the criminal justice system, and of course has a racially disparate impact and bakes in disparities based on disproportionate policing of different communities, et cetera, I don't really know that it is necessary to give judges who already have criminal history in many states as one axis of the sentencing guidelines to give them another thing that is like that, another thing that puts a thumb on that, on the scale in that direction. So while I think it's not constitutionally troubling, I'm not sure that it's a great idea from a policy perspective. In the bail context, like, because the money bail system is such garbage, like I'd rather just see another alternative. Again, like real enforcement of the Eighth Amendment. But that said, it might be better than the money bail system. So I do think that judges are always going to, I'm not a pure retributive justice sentencing advocate, right? I do think that looking backward at what the defendant deserves is certainly morally relevant, but we've always had utilitarian purposes of the criminal justice system as well. I don't think judges are about to stop considering whether a defendant is dangerous in some ways, and it is possible that that will always bake in some kinds of biases. Maybe things like implicit bias training, et cetera, could have some positive impact on that. So whether we do it algorithmically through things that, through a criminal history-based instrument versus individual decision-making, I guess like one thing I would say is that it's not really the case that you have a choice between those two, because so long as the risk assessment instrument doesn't dictate the sentence, which it doesn't, right? Then you actually could just be baking in biases in the instrument in addition to all the other biases an individual judge may have. So I'm not sure that the move to risk assessment actually solves the problems with individual decision making.
So let me just press that a little bit further. I'm really curious what the rest of the panel thinks. Is criminal history the only factor then that could be considered if we're going to do risk at all? Or is that too problematic given all of the connections between criminal history and socioeconomic factors and regulatory? So I'm asking the same question but fine-tuning a little bit more.
Well, I mean, I think the law clearly permits age to be used. We use it for everything in the law. And
As an ethical matter, too. This is about ethics as much as it is about law.
And I think that the age factor maybe troubles me a little less because it's something that like everyone passes through ages in their life. It doesn't systematically lead to distributive justice problems in society. You know, those psychosocial factors, the interviews about people's attitudes, in some ways I think capture something that individual decision makers probably do, right? Like they probably, individual judges long before risk assessments probably did try to appraise, like, does this defendant have a bad attitude? And I don't think that that's irrelevant to a proper sentencing process. I just worry about the way it's actually being implemented. In part, I think a lot of people are being basically compelled to sit for interviews. That, I mean, this to me raises a self-incrimination problem. But also, you know, if you use things like, do you think the criminal justice system is fair, right? And you ask people, and like saying no to that question gets you points added to your score. Well, you know, maybe there are groups in society to whom the criminal justice system isn't fair, right? And that's also a proxy for various kinds of things. So.
Any other thoughts? Andrew?
So as a former public defender before teaching, I can tell you that all my clients thought it wasn't fair, certainly at the moment that they were about to be sentenced, because they felt that there were these power dynamics that really weren't fair. But what I think is useful about these sort of algorithmic judgments, even things like Compass, is it allows you to interrogate some of the underlying assumptions that have always been going on in sentencing and judgments, and it allows you to push back in a way that you can't push back with a judge, to say, Judge, you really shouldn't be taking these considerations into account. The fact that this person's parents went to jail should not be a factor. And we can articulate that. Whereas before it might have been implicit or explicit in people. And the ability to sort of break apart and see factors as separate factors that might be influencing, I think is actually helpful to the conversation. It may mean that eventually the political judgment that we don't use certain factors because we've made a political judgment, not because they're not accurate, not because they don't correlate, but because we have decided as a polity not to use it. But I think you can't have that conversation without the sort of data-driven focus allowing you to visualize that these are all different inputs. It sort of breaks it apart in ways you can see it in different ways and then have an interesting conversation. Lots of people have negative impact and negative feelings about the criminal justice system. Lots of people have recognitions that their friends might be influential but shouldn't be determinative of their futures. Some of us have had bad friends in the past. But what it allows you to do is actually see it in ways that you wouldn't be able to see and maybe correct it. If we can take this as a conversation to go forward, maybe the initial move to risk assessment allows us to sort of refine and retune or tune up some of the inputs that are going in.
Yeah. Hi. Maybe I'll actually take on the use of gender in these scores, because I think that's particularly controversial. I'll try to make an argument of why not only is it permissible, it would actually be unethical not to use it. And so in many jurisdictions that we see that conditional on a variety of factors, including criminal history and other things, that women are less likely to recidivate compared to similarly situated men. And so if you don't use gender, you're in fact biased against women, and that people that we know, I mean, defendants that we actually know are relatively low risk, that we're going to treat them as if they were men, and now we're going to assume that they're higher risk. And it's not just a little bit. This, in fact, can be, in some jurisdictions, this is quite a big distinction. So we see, literally, we're saying that we know statistically this defendant who's a woman is low risk, but if she were a man with the same criminal history, then she would be relatively high risk, and therefore we would detain her, set high bail, and so that's what we're going to do. And in my mind, that's actually fundamentally more unfair than to simply use gender in the risk assessment itself. And the core issue here is one of anti-subjugation versus anti-classification. And I think a lot of what people's ideas of not using gender or race or any of these other features in the model is because we feel like it's going to be used in some way to oppress a group, but the classification itself doesn't necessarily have to do that. And so recognizing that there might be differences in this way can actually lead to, I would say, more equitable outcomes. And so that's a reality that we have to at least grapple with. And in theory, the same thing can happen with race. And so this comes up if you say that there's going to be there's over-policing in high crime, high minority neighborhoods. And so if you're Black or Hispanic, you're more likely to be arrested. Well, in theory, if you were to allow for race in these types of risk assessment tools, you would learn that, in fact, if you're a Black defendant with a relatively long history of minor criminal arrests, in fact, that doesn't mean nearly as much as if you're a white defendant with that similar rap sheet. So in theory, this is a theoretical argument. In practice, we looked at the data, and we don't see that race comes in, and so you don't have to use this type of kind of race-specific scores. But in gender, we see this all the time. And I just want to, push back. And there was this one, this claim that it was obvious that this is a constitutional problem. I would say it's not at all obvious. For part, this is with gender, it's intermediate scrutiny, not strict scrutiny, and so the bar is far lower. Not only is this in theory, in practice, in many jurisdictions, they're using gender-specific scores, recognizing this problem. And so I think it's debatable. I think there is sort of a lively debate that one could have on whether or not we should use it. But I would say it's far from a clear, constitutionally settled question. And I would say statistically and ethically, it's also far from clear what we should do in this case.
Okay, so the intermediate scrutiny, though, is a pretty high bar, right? And there are a ton of cases in which the Supreme Court has considered character or vectors along which the statistical differences between genders are clear, right? So in the classic gender discrimination case, the Supreme Court struck down a differential drinking age for men and women, which was premised on studies that said that young men were 10 times as likely to drive drunk as young women. That was true, and people's lives depended on that. And the court said, nonetheless, you can't base differential treatment on generalizations about the way people of different genders behave, because even though something may be true on average, the average isn't true of all individuals, and we have a constitutional principle against lumping people into groups. In principle, I'm sort of on the anti-subordination side of the big theoretical debates about equality law. But I do think, I want to give tools to the people in the room who may someday be representing clients who want to challenge their risk assessments. Our law is not on that side. And I think the anti-classification principle is clear here. Anyway.
Jennifer.
I'll just say something briefly. I think that so much of the confusion in this space is introduced by bringing one thing, risk assessment, which is forward-looking, into another thing, sentencing, and a very punitive system, which has been backward-looking. And it is so easy, it happens so fast, that when we're talking about a given thing, criminal history, gender, age, antisocial attitude, we conflate what they are and how they're being considered really quickly. So things like age and gender are not at all relevant to blameworthiness or culpability or retributive concerns. They are risk factors. They have been empirically demonstrated to increase your risk of future offending. So yes, this context has to constrain the risk factors that are eligible to be included in a risk assessment. At the same time, I think it would be a huge mistake to say, oh, all of these might be associated with X, Y, and Z, so let's exclude them, and focus instead on criminal history, which got us here in the first place when we're talking about disparities. There's actually pretty good evidence for that. So I know that it's an ideal theory, but again, the idea is that you would be able to first say, this is what this person deserves on the basis of the crime, the criminal behavior, the facts, the law, etc. And then and only then shift focus out of blame territory into risk territory to look forward and say, within that space, should we go higher or lower with a provision or with detention or with whatever else? I've been in too many conversations with sentencing commissions at this point where they express concerns about risk factors that are really related to blameworthiness, and then land on criminal history as a solution, which I think is exactly wrong, because it gets them deeper into the hole that they're trying to avoid with respect to racial disparities.
So I'm going to predict we are going to go all the way till 2 o'clock, and I promise you'll get a chance to ask some questions, but I want to throw out 2 more questions to the panel. And actually segues from what Andrew said earlier, but was raised by all of the discussants. And that is this issue of transparency. We can't really get into the kinds of issues we're talking about unless what the actual device or the machine learning device does in terms of its code, in terms of the kinds of factors it's relying on. So what can the law do about forcing transparency? If transparency is forced, will judges and courts understand it sufficiently? Will even computer scientists understand it sufficiently? For instance, it's based on machine learning. I think it's useful to talk about that as a predicate for everything else we're talking about. In response to that question.
Maybe I'll reiterate this one comment that was brought up earlier. I'm not sure if you said it, but machine learning is a bit of a red herring. I mean, I use that word when I want to get grants, but let's be serious. We're talking about linear regression. And we see very little in this particular context. There's not a lot of benefit to using these nonlinear, black box models. You're not going to be using something like a neural net to predict recidivism. I just don't see any evidence that that's actually effective over these very simple checklist style rules. And so in that sense, there seems to be very, very little statistical motivation for having something black box. And because of that, I think a lot of these trade-offs that people argue are mostly hypothetical. In practice, we can have everything. We can have something that's accurate. There's a fairness issue, which is a little bit separate that I'll sidestep for now, but we can have something that's as accurate as we want and also more or less as transparent as we want. And I think the issues are more political or issues of IP. And again, I'm pushing back on this IP issue. When you're really talking about when you're talking about intellectual property, the issue here, if your fancy algorithm is fit logistic regression, I don't have much sympathy for the IP rights in that particular instance. So I think that states should just refuse to contract with for-profit companies that are trying to peddle these things that honestly my undergraduate students in my intro stats class could develop just as easily.
Andrew?
There's an interesting reality playing out in the place-based predictive policing world where companies who are trying to get contracts with various police departments around the country are also competing around transparency. So some of the first companies out were companies that kept their proprietary algorithm secret, in part because it was a good marketing idea, that it was a secret black box thing that you needed to get. It may also have been a simple algorithm that they didn't want to reveal. But some of the other companies, in sort of trying to compete with them, have actually marketed themselves as transparent. We're willing to open up what we're doing, we'll show you our code, we're willing to go to court, right? A lot of these things are going to end up in court where some judge is going to have to say, counsel, what's an algorithm, right? Or the equivalent. And lawyers who are lawyers because they don't understand these things, that was me, are going to also have to litigate this in a way. And so you've seen these companies sort of embrace transparency as a marketing mechanism to actually get contracts so they won't have this debate. I do think, though, that in the nearish future, some of the technologies will start using, or at least they claim they're experimenting with machine learning. And then you get into an interesting problem where you might not be able to peel back some of the issues, and maybe transparency is not the word you want, but accountability is. And there's an interesting debate going on in the computer science world about whether maybe what we should be pushing for is accountable algorithms, to borrow the phrase in the law review article about it, as opposed to transparent algorithms. Because again, for most people who are not in this room, like, you could show them an algorithm, they're not going to understand anyway. So what, transparency doesn't help.
Okay, so I have one last question and we'll get to the audience. So let's assume we are going to use these kinds of instruments. And let's assume they are transparent. And let's assume that judges and others who use them understand them. All three big assumptions, but let's assume all of that happens. Should we require the decision maker to abide by them? I know Megan's done some interesting research about the use of these instruments in the pretrial detention context. In a situation where, in Kentucky, judges were told to use these instruments, and in fact, initially, they did use them, but slowly but surely, we saw judges exercising their discretion and slowly but surely paying much less attention to the risk scores that are produced by the instrument. So was that a good result or not? I'm curious, and that really raises this tension between accuracy on the one hand and the need to have more humanization of the process on the other. So I'm curious what the panel thinks about that.
So risk assessments can be used in a myriad of different ways, and my concerns with them change depending on how they're used. When I advocate for the use of risk assessments, I do it mostly in one specific way, and I work mostly in the pretrial area, so this has to do with the pretrial context. I say, well, first of all, let me back up. So one of the arguments for risk assessments, algorithmic, computer, or at least checklist, some sort of risk assessment instruments, is that they're better at predicting future offending than judges. And this may be true to a certain extent. Another argument which gets a lot less attention is that it's just kind of a quick and dirty way to make decisions. And in the bail context, the status quo in most jurisdictions is that somebody gets arrested and then they spend a day or two sitting in a jail holding cell, and then they get a bail hearing that literally lasts for 1 minute long, and then there's a monetary amount, they pay it or they don't. So what I think would be really useful in this way is a quick and dirty way of releasing way more people so they don't have to sit in jail for 24 to 48 hours. And this doesn't have to be a risk assessment. It could be a simple rule that anybody facing a misdemeanor gets released immediately with no monetary bill. But if you want to kind of broaden your net and include, okay, well, let's say there's probably a certain number of felony defendants who should be able to be released immediately. Well, which ones? Let's look at their criminal history. You can quickly make this slightly more complicated, and then all of a sudden you have basically a simple risk assessment instrument, and what you have is a quick rule, like a quick way of determining, you people, almost all of you, go home. Then once people have gone home, and I kind of gave the sort of like 2-second spiel of this earlier, you now have a lot more time. Instead of the judge having to run through 1 million bail hearings, they can take the time and actually do a bail hearing, right? So the risk assessment is not necessarily used in determining who's detained, but it's a way of like quickly releasing a bunch of people. So that being said, the rule that I'm proposing in this particular context is not discretionary. There's no judge coming in saying, I'm looking at the risk assessment and I'm also taking my intuitions and kind of making some mishmash combination of them to make the decision. But I wouldn't go so far as to say that I think that should be a rule per se, just that in certain contexts it might make sense.
So, it won't surprise anyone that I am not going to say that judges should be required to follow risk assessments. But in the sentencing context, I think it would be impossible to do that in light of the competing different sentencing considerations like moral desert, etc. I do want to say about those competing considerations that one of the interesting things about the risk assessment is that it treats effectively as an aggravating factor various characteristics that are often actually treated for retributive reasons as mitigating factors, right? All those socioeconomic disadvantages. In some contexts, depending on who the judge is, maybe, it's defense counsel that try to introduce that information by way of telling a story of how the defendant came upon like a life of crime. And I think that like whether we had quantitative risk assessments or not, those types of factors could cut in different ways depending on whether the judge is retributively inclined or inclined toward an incapacitation-based approach to criminal justice. I do think that when you use a quantitative risk assessment, the state is putting the thumb on the scale in favor of judges emphasizing risk determinations. Because most judges try to take all this stuff into account, but they're not really told whether there's risk assessment or not. Like, what is the hierarchy of concerns here? Does one thing constrain the range of options for the other? Like, we just have sort of left all this up to judges. Like, judging in a way is a black box, right? And with risk assessment, I think like there's lots of empirical evidence in lots of areas that when you quantify something and attribute it to experts or science, et cetera, that decision makers place more weight on it than they do if they think they're just like making their own judgment. I did that in my article, just like a little stupid, but yeah, I thought kind of informative experiment with my law students in which I gave them the same pieces of information about two defendants, which tended to make one of them seem more morally sympathetic and yet higher risk than the other one. And then the thing I did was half my students I gave risk scores to, and half of them I just gave the underlying facts, right? The ones that I didn't give the risk scores to gave substantially lower sentences to the person with the poverty-related backstory, right? And when I did give the risk scores, that it turned. It was equally large difference in the other direction. And I think it's, granted, it's just a vignette given to law students, and they're probably particularly susceptible to little pushes like that. But I do think that, like, when you say the state wants you to consider risk, and here's a scientific way of doing it, you're gonna make that carry more weight than it would otherwise, in at least some judges' mind, vis-a-vis the other considerations of criminal justice.
So any other comments? Ready to go to the audience? Audience ready? Questions? Yeah, let's start over there. We need mics. So don't say anything until you get a mic.
I'm wondering, since the discussion seems to revolve around a lot whether this system is better than what we currently have, that if in doing risk assessments and algorithms, why don't we just try to control for discrimination somewhat so that you can reduce the underlying societal discrimination that's going on? Why couldn't an algorithm include that if you're arrested for marijuana possession and you happen to be black, that it could be discounted somewhat or something like that that would actually reduce the effects of discrimination? Because otherwise, isn't the algorithm and the risk assessment just reflecting the societal discrimination that's going on anyways?
I think the answer to that in practice, like, you could, and I often see computer scientists proposing things like this. The lawyer answer is that a court would strike that down lickety-split, like explicit consideration of race. We just don't do it, right? I mean, you could say, like, in a very limited context, affirmative action in certain settings, courts have been barely reluctantly willing to allow government authorities to take race into account as a way of responding, but not even as a way of responding to other differences in society. The only justification they permit for it is, like, educational diversity. And so I think that, like, your suggestion is, like, super interesting, but I just don't think it would fly in a courtroom.
Title for the article: Algorithmic Affirmative Action. Any other?
Yeah, maybe I'll jump in. I'll say, so again, reiterating this point that I made earlier, we've actually looked at this. We don't see a need for it. And so a lot of these, so there are two types of bias that can come into algorithms. One is in the labels, and one is in the features. And so the features are, like you're saying, like arrests for minor crime. And in theory, if you're trying to, if you think that minor crime means something different for whites and blacks, then you would want to fit two different models. That's one way of dealing with it. And empirically, we don't actually see that coming up, but we do see this for gender. And so I do agree that it would be problematic legally to use race, in part because we have a stricter standard for race, and in part because the empirical evidence isn't nearly as strong. But with gender, not only this, I mean, this is being used across the country, so I'm not sure if these cases just haven't been raised, but I think there's actually a pretty strong statistical argument and social argument for using those types of characteristics in the algorithm itself. The second part of it is in the labels, and so this has come up a few times, that the thing that you're predicting is only a proxy for the thing that you care about. So you fundamentally, let's say you care about commission of violent crime, all you observe is arrest or conviction for that crime. And that is, as Jen has shown in some of her work, that this is probably a better proxy than you might think, at least for the connection between a marijuana arrest and marijuana use, where we know that there's not much connection. But that is hard because you never observe what you don't observe. And so there's not an easy way. You can't simply say, okay, I'm going to use my algorithm to, like, discover this thing that I don't observe, because the problem is you don't observe it. And so that's tricky, but I would say it's not only algorithmic. The human decision maker has the exact same problem. So the human judge can't simply say, oh, well, I know that this is actually the rate that you're going to do this thing. It's like nobody actually knows. So it's fundamentally tricky.
Although you could theoretically, so I agree that doing this in practice and building into the algorithm is tricky. You could train judges to consider these things when they're looking at a risk assessment algorithm, to consider the fact that a certain defendant might have grown up in a particular neighborhood that would have made them more likely to have a number of arrests, which might partially mitigate the issue.
I will say, like, maybe you could do something like what you're talking about if you tried to, if instead of trying to adjust it for race, you tried to adjust it for, socioeconomic related disparities, because courts are friendlier to that generally. And while they don't like discrimination against the poor in the criminal justice system, would they be willing to have things that offset discrimination against the poor? Like, maybe. So just like in the affirmative action context, courts in general have been friendlier to class-based approaches.
So that maybe one final comment agreeing with this point is that the reason statistically why we think we don't need race in these algorithms is because it's correlated with so much other stuff, and so you get it for free. Like, I don't need to use race, and this is the argument that a lot of people use to say that, well, race is already baked into your algorithm. It is, and I actually think that's a good thing, precisely because we're actually able to get better calibrated, more precise risk scores in this manner. And it's just harder to do that with gender. So gender isn't nearly as related to a lot of the other features in the algorithm, and so for whatever reason, then we need to explicitly include it to offset these types of issues that we're seeing. But with race, we get it for free.
So there's an interesting example of this phenomenon. The state of Pennsylvania has been developing a risk assessment instrument for sentencing purposes, and the original algorithm included location as one of the risk factors, but there was a huge public outcry against it and it was removed, and probably for some of the reasons we're alluding to right now. So there's a question here, and if you can hand the mic to the people who have their hands.
Yeah. So my question is actually for the place-based policing. And one, I'm come from an education background, so one of the things that we find a lot of times with these big fancy algorithms is that they kind of tell us what we already know. And one of the things that you mentioned was that they've changed where police are actually going to. And my question is, how often do these things actually end up having police go to neighborhoods that are already not heavily policed in Chicago?
It's a good question. So the police officers who are told to use the algorithm will say, well, I already knew all this. But the companies that are selling it say actually they are seeing different patterns and different places to go. In part because the areas are they really are narrow, it's like 500 by 500 square feet, it's like a city block. And in part because sometimes the assumptions of where crime is happening isn't quite accurate. It doesn't to say that the predictions are accurate themselves, but they do see a difference so that the folks who are buying the technologies think there's added value. I think it's an open question about whether it is or not.
And John?
Okay, so I'd like to ask a kind of hypothetical here. You've been talking about before trial and after trial, so... Okay, so I'd like to ask a hypothetical here. You've been talking about before trial and after trial, and if you didn't have obstacles in rules of evidence or whatever, would you trust these risk algorithms enough to advocate for them being introduced in the trial phase as kind of a Bayesian prior for the defendant's prior likelihood to have committed the crime in question?
No, and I think that a court would also not permit them to be introduced for that reason. But just like we don't, in general, like we even have rules about like inferring the probability of guilt of a current crime based on the defendant's own prior conduct, right? Normally, it's hard for a prosecutor to get that in, and so. Introducing evidence about what other people who are actuarially similar to the defendant do. No way, that's just like not gonna fly, but thank God.
Not to mention, these tools aren't that great. Like, it's just hard to predict crime even if you have a ton of great variables and a huge data set. Like, they just don't give a ton of information.
I think what's interesting about your question is I think a lot of jurors are doing some of that same negative correlations themselves. And then actually articulate, not that I'm certainly not suggesting that would happen, but I think you might want a jury instruction saying why you shouldn't be doing this, right? Why you should be looking at individuals and you shouldn't be looking at proxies, because a lot of jurors who see a defendant and don't know who that defendant is, especially the defendant doesn't testify, are using some of the same proxies that we're thinking about here based on gender, age, race, whatever it would be, and actually calling people out that they shouldn't be making these assumptions. Exactly why we have certain jury instructions, and I wonder whether the debate might trigger people to actually be more aware of that rather than allowing what I think are a lot of implicit and really explicit biases to play out in our court systems every day.
So my question is that I think looking at the trying to predict recidivism rates or flight risks or in sentencing or bail hearings, isn't that a discriminatory process even in and of itself, since you're trying to predict something that hasn't happened yet? And if so, any features you use are going to be discriminatory in some way, and so should that even be considered in your sentencing, or should it just be purely backwards looking based on what has happened instead of what might happen?
That's a very fundamental question. I don't know if anybody wants to take it on. Should our system be entirely backward?
I don't know about discriminatory. I mean, I do think that Andrew's right that decision makers and everybody's right that the baseline of human decision making is not bias free, right? And so yes, predictions about the future that individuals make are likely also to build in biases. I think your question is even sort of more basic than that, which is is it somehow unfair to make a defendant's sentence today contingent on a prediction about what they might do tomorrow, regardless of whether group identity issues and stuff come into play. I hold sort of as a criminal law philosophy matter largely to the view that Jennifer raised, that one's moral desert, the sort of purely backward-looking viewpoint, ought to be a constraint on the state's power to punish, right? And that other factors about making society a better place ought also to be constraints, right? That we shouldn't be punishing people just because of this sense that we think they deserve it, if doing so is going to make society worse off. And I do think it's almost impossible to imagine a world in which sentencers thought about how is my sentence going to affect the world without thinking about the dangerousness. If you have a serial killer is going to be locked up forever on retributive grounds anyway, so that's a bad example. But let's say you have somebody who is convicted of assault and they have a long record of torturing animals and doing all the things that make you think this is this person, we want them off the street. Do I think that should be taken into account? Yes, I do, and so I'm not in favor of extracting future orientation entirely from the criminal justice process.
I think it's also interesting to consider discrimination point of view when you're looking at a purely retributive system, like you're suggesting. Let's say we have a rich thief and a poor thief. Is it fair to sentence them to exactly the same sentence, given everything we've been talking about? Arguably, the poor thief is less culpable. And should be treated differently, but that's not the way we do it. So it's not discrimination. And can we avoid discrimination? I'm sorry, you're talking about. There was, where? Okay.
So to what extent is there, or do you think, should there be societal concern about creating a feedback loop between predictive policing and the use of risk assessment in collateral proceedings, whether they be bail or sentencing? Because it seems they would use the same input, so it would run the risk of just over-policing the same place over and over again.
So right now, they're sort of proceeding on separate tracks, but I think in 5 years or maybe less, we'll be talking about predictive prosecution as how prosecutors' offices are changing to be more proactive about targeting individuals. And part of the inputs are those is also the larger criminal justice systems of prosecutors as opposed to just police are places like Manhattan, DA's office, other places are using and have access to, parole decisions, probation information, and some of those, presumably some of those risk assessment terms. Right now, they're still separate and no one's really linking them all together. But I think as we move toward a sort of growing sort of combination of data sources to try to understand crime patterns and who's involved, to sort of see individuals not just at the front end or just in court or in the back end, but actually see so there's like full loop of understanding where people are going and when they're coming back into society. I think that we will see some of those scoring factors impacting. I think that in Chicago, if you have a 500 plus threat score that might determine whether or not the detectives come to your door, and that's in the system, it hasn't happened yet, but I'm hard pressed to believe that that's not going to keep showing up as you go through your life, where people are going to know that, oh, this guy was rated as one of the most at-risk people in Chicago, be it as part of the probation decision. I don't know where it'll be that people will find it, but I know that when you get stopped in Chicago now on the police dashboard computer program, your score shows up, 500 plus. And you actually can go as a drop-down to understand why. Like it'll show you some of the variables that are part of it. And I can't imagine it's just going to stay in the policing world's hand. I think it's going to expand to the larger criminal justice system. It hasn't happened yet, but I think it's a concern that we should be aware of for the future.
I'm sure Andrew's predictions are right. God help us all. I do think some of this is baked into many aspects of our criminal justice system, right? So, we sentence people based on criminal history, right? We also, and that bakes in, arrest disparities at one stage lead to a longer sentence or lower, and having been incarcerated in the past, counts against you in subsequent criminal, and so you see, from throughout a defendant's life, ways in which disparities can be multiplied across processes. There's some work, I think it's by Kelly Hannah Moffat in Canada, about, so Canada is really big on risk assessments in lots of aspects of their criminal justice system, and she actually showed that some risk assessments that were being done for one purpose, I can't remember if it was bail or maybe it was like assignment to security conditions in prison or something, but it did follow along later on and got used by parole wards later in the process.
So I just wanted to say, in terms of feedback loops and racial bias, let's just say we have a risk assessment tool that's at least as racially biased as the status quo. Is adopting it going to lead to greater, is that going to embed racial disparities in our criminal justice system? I mean, possibly. I'm not saying this is great and we should adopt it, but it depends on how it's used. If it's used in a decarceral method, you have a risk assessment tool, it is biased, but what it does is the way it's incorporated into policy means that there's way fewer people in prison and jails. These are fewer people of color, because primarily who we send to prison and jail in this country are people of color. You have fewer people of color in prison and jails. There's a beneficial ripple out effect on their community to the extent that prison and jail is criminogenic in terms of it increases the experience of being incarcerated, it increases future crime, which some research suggests is the case, at least in the United States. Then you have, less crime and less chance of being caught back up in the system in the future. So feedback loops are it's hard to evaluate, but I do think it depends on how it's used, and it can be sort of, it's not necessarily straightforward.
So I will sound like a broken record at this point, but it's compared to what? Bernard Harcourt wrote a beautiful book called Against Prediction, which is all about our system's reliance on criminal history, which he argues has had a ratcheting effect on racial disparities over time because of some of it's similar territory in terms of feedback loops. It's different in the sense that the data that could potentially be shared is broader, and if it's risk assessment in the way that I know it, it will also include many different domains of variables instead of criminal history. So I don't know how it would have an effect, but I can easily imagine how something like a high-risk label could follow one in the same way that criminal history does now, and it accomplishes pretty much the same thing.
So I think it's fitting our last question will be Andreas.
So this has to do with the general issue of we have a flawed system now where humans are making decisions, and so we go to a system with algorithms making decisions, and so that at most is equally flawed. We had a symposium last week, and our keynote speaker, Patrick Ball, who works on human rights, made a couple points, a couple arguments, that in fact the algorithms will, not the algorithms, but the algorithms in the data will make the problem worse, and I'd like you to react to those. So the first one has to do with feedback loops, and he showed us a map of Oakland where that was colored by drug use collected by health professionals, and it basically showed that everyone in Oakland does drugs. And then he showed us the map of where police arrests are for drugs. And of course, they're predominantly in the poor neighborhoods, in African-American neighborhoods. And so then, he showed us a simulation that he did, where he took one of these algorithms that is used, and you see that over time, the disparity becomes even worse, because once so obviously the algorithm finds that these spatial regions in the city are the ones where we should send police cars to, because that's where all the arrests are. Because of course the data is not drug use, it's where the arrests have been. And so that sends the police there, so you continue that trend. But once you start training on that new data, the algorithm becomes ever so successful in zeroing in on the trend, and so the disparity just becomes worse with time than it would have become if you didn't use the algorithm. That's because algorithms are better than people at finding the perfect trend in the data. So that's the one thing. And the other thing is that, in terms of the black box, so I guess, Megan, you said the human brain is a black box, and that's true. On the other hand, the human brain is a black box that all of us sort of intuitively understand, and we can talk about it, even if we don't really understand what's going on, we can at least talk about it, and everyone can be part of the conversation. Whereas once you have an algorithm, even if it's a simple linear regression, 97% of the population is excluded from the conversation. They don't understand it, they don't know how to talk about it, and so then it becomes, an issue for experts. And that makes it inherently more dangerous because most of the population gets excluded from that conversation. Whereas if it's a judge making a decision, people can stand up and say, "That's wrong. Why did you make that decision?" And they can't do that if it's an algorithm.
Okay, simple question.
I'd like to take the first part of that question. So I think that the study you described is an object lesson on the risks of potential use of algorithms, but also why maybe we shouldn't be as worried as he might say. So what they did was, in that study, was to say, if you use one of the leading predictive policing technologies, Predictive, and you study drug arrests in Oakland, you will have essentially a racist system because you'll just be replicating where arrests are. Predictive, as a company, doesn't use arrests and doesn't look at drug arrests. It doesn't even look at drug crimes, specifically because of the concern that they know if they did that, they would create this feedback loop. And so here you have a company that, based on that study, was taken to the woodshed in the press, saying that your algorithm is racist, when really they have designed their algorithm to avoid this obvious misstep, which would be to replicate a sort of racialized policing practice. To me, that's a positive lesson, although it wasn't pitched that way in the media, where it says here are companies that are trying to take some sort of ethical responsibility. And I make my career criticizing Predictive, but at least in this sense, I think they've done it right, to say that we know if we use arrest, we know if we use drug crimes, we're going to create a flawed system. So we're not going to do that. We're not going to put that in our system. And so I think that the study is useful to show unthinking sort of predictive policing will create problems. But to me, the flip side of that is thoughtful predictive policing might avoid at least those problems. Maybe it creates other problems, but this is going to avoid those problems.
Any last comment?
Yeah, I think these are important issues for 20 years from now, at least in the criminal justice risk assessment, in pretrial sentencing, parole context. The tools that are currently in use, virtually every single one of them could be understood by a 9-year-old. We're not even talking linear regressions. Maybe they did a regression at some point, hopefully cross our fingers, but right now it's you add 2 points for having a prior felony conviction, 1 point for having a prior misdemeanor conviction, 2 points for being 19 instead of 40, and so forth. And things move really slow. So that being said, it's a little hard to think about what it's going to be like in 20 years, because maybe the sort of the average understanding of these types of tools will have grown at the same rate that their sophistication has.
Sorry. Jennifer?
Just very quickly, I know we're out of time, but I agree with what Megan just said, and also this can be a part of an open conversation. So the Pennsylvania Sentencing Commission bears that out. They've had endless discussions about what is eligible to include or not include in their risk assessment, and they very carefully consider social justice issues and weigh, if we take this out, what does that do to predictive utility? If we substitute it with convictions, what does that do? So I think it can be an open process. The other thing is we aren't very good at talking about what's in our heads. Nisbet and Wilson were the first to really show that as human beings, we have a hard time articulating why we made a decision that we made, what really went into that. So I just sort of leave both of those as responses.
So I predict this is going to be an issue for a long time to come. Thank you very much for attending. I want to thank our panelists for a terrific discussion.